Supreme Court, I'd like to report a murder. A murder. Oh my gosh, I haven't seen a takedown like this in a dissent by a federal judge, maybe in my entire career. There is blood on the walls, on the ceiling. It's everywhere, metaphorically speaking, YouTube. Just no actual judges were harmed in the writing of this dissent except emotionally. It is amazing. I'm not sure I've ever quite seen a dissent like this. So yesterday, a 3-judge panel in the Fifth Circuit down in Texas, in a 2-1 decision, Federal Court of Appeals panel, decided to issue a stay against the new Texas redistricting map. One of the consequences of which it eliminated the district of entertaining Texas Congresswoman Jasmine Crockett. That clown looked like her seat was going away. But this 2-1 decision, Federal Court of Appeals said, no, we're not going to allow Texas to use its map, which would have gained the Republicans 5 congressional seats. Of course, they're going to let California go ahead and gain Democrats 5 congressional seats. But this judge decided that he was simply not going to allow this. Judge Jeffrey Brown wrote the decision for the 2-1 majority, freezing the Texas redistricting, telling Texas it had to instead use an old 2021 congressional map. And I looked at that decision when it came out yesterday, and I got to tell you, I wasn't going to cover it. I started reading it, and I was immediately struck by the best way to describe the decision is estrogenic hysteria. I mean, it's ridiculous. The judge's evidence is things like articles written by the New York Times. It's crazy, and it was 160 pages long, and I was like, I'm not going to spend 4 hours reading this to my audience. And then today, just minutes ago, dropped that one judge on the 3-judge panel, his dissent, Judge Jerry E. Smith. And he just drove a metaphorical spear through the liver of that majority decision with such heat. I said to myself, I have to share this. I have to share this with my Andrew Branca Show audience. This is fantastic. Now, the majority opinion was 160 pages. Judge Smith's dissent is 100 pages, so I'm not going to read all of that either. But the fun stuff is mostly the first 20 pages and the last page. So we are going to cover that, and it's going to be a lot of fun. I had Emily bring me my tea. It's going to be a blast, and I'm so glad all of you are here for it. Oh, we got a couple super chats already. So let me jump into that. Oh, 2 new members. That's awesome. Cell Brown and MC both became members. Welcome to the family, folks. You picked a good one. You picked a really good one to join. All right, so let's start with the yesterday's order, freezing the new Texas congressional redistricting map. And we're just going to cover a few bits and pieces of it just to give you a flavor of it before we get to its graveside murder by Judge Jerry Brown. So let me pull this up. Let's see, share this window. Here we go. Judge Jeffrey Brown, sorry, Your Honor. That was not intentional on my part. How's that? Can we all see that okay? I'm going to move this over. So again, this is the order from yesterday that told Texas the court was not going to allow Texas to use its new congressional map. 2-1 decision, 3-judge panel. So it's just a quirk in the law, by the way, folks. It doesn't come up very often. But when there's a state congressional district legal argument, it skips the normal initial court, the unelected black robe tyrannical inferior federal district trial court. It skips the trial court and it goes right to a 3-judge panel. So this is what's happened here. And by the way, this is a consolidation of cases that have been going on since 2021. So all these legal arguments started way back in 2021 when lawsuits over Texas redistricting, it's been going on forever. But this came down yesterday. Jerry Brown. Oh, I keep saying that because he was the governor of California. Jeffrey Brown, United States District Judge. It's not a court of appeals panel. It's a district judge panel. It's a trial judge panel, but it's a 3-judge panel. Normally, when you have a 3-judge panel in the federal system, it means you're at the appellate court level. But because this is a redistricting issue, it automatically goes not to a single trial court judge, but to a panel of 3 trial court judges. These are not normally appellate court judges, and they don't normally work. District trial court judges don't normally work in panels of 3. I kind of get a vibe here that they weren't used to doing this quite this way. So Jeffrey Brown, and I'm just going to cover a few of the highlighted portions here. In August 2025, the state of Texas enacted a new electoral map to govern elections for the U.S. House of Representatives. That's called the 2025 map. Claiming that the 2025 map is racially discriminatory, 6 groups of plaintiffs asked the court to preliminarily enjoin, so a preliminary injunction, enjoin the state of Texas from using this new 2025 map for next year's 2026 elections. For reasons explained below, the court does preliminarily enjoin the state from using the 2025 map. The court orders that the 2026 congressional election in Texas shall proceed under the map the Texas legislature enacted in 2021, which was ages ago. It was a different legislature and everything. And then he starts with a quote from Chief Justice John Roberts, which I find so ironic because the quote is, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." But this is a redistricting case. And so it's being constrained by the Voting Rights Act of 1965, Section 2, which, by the way, is also right now being argued before the Supreme Court from the Louisiana redistricting case that I've covered with all of you before. So this opinion is being handed down by this judge at a time when he knows it's quite possible the Supreme Court is going to completely change all the rules for redistricting. In any case, because this is a redistricting case, race is always involved. The whole point of the 1965 Civil Rights Act, Section 2, the way it's been applied, not the way it was written and intended, but the way it's been applied by the federal courts, is to be race aware, to set up majority minority districts and what they sometimes call coalition district, where there's no particular race or ethnicity that's in the majority, but you can combine black voters and Hispanic voters and gay voters. I don't know how they do it, but you build a coalition that's majority. As long as white people, as long as white voters are in the minority, it's all good to go. The whole conception of all of this is racist. It's not race blind. None of this is race blind. And he starts off with a quote from Chief Justice John Roberts that essentially says, if you want to stop racial discrimination, you effectively have to be race blind. He doesn't do anything like that. Nothing like that happens here. So I found that notable and laughable. And I'm going to skip back a bunch of this. I just highlighted a few portions I wanted to share with you here. When I got to this point, I really LOL'd. So now, just to be clear, you're allowed to redistrict. A state is allowed to redistrict for politically partisan purposes. So the Democrats are allowed to redistrict so they have more Democrat seats. And the Republicans are allowed to redistrict so they have more Republican seats. Partisan-driven redistricting is perfectly lawful, perfectly allowed. You're not supposed to do it for racist reasons unless you're supposed to do it for racist reasons to satisfy the federal courts and the Supreme Court's case law on the Voting Rights Act of 1965. But He says calls to redistrict for political purposes, which would be fine. But he starts drawing his evidence for this 160-page order. What's he using? On June 9th, 2025, the New York Times published an article. Does anybody believe that the New York Times is a reliable source of information, of facts? Facts used to completely neuter one of the largest states in the nation's redistricting plan? You're going to gut what the legislature of Texas decided to do because the New York Times published an article? Are you shitting me? The New York Times published an article reporting that, quote, President Trump's political team was encouraging Republican leaders in Texas to examine how House district lines in the state could be redrawn ahead of next year's midterms elections to try to save the party's endangered majority. Because, of course, right now the Republicans have only a slim majority in the House. Contemporaneous press coverage. So, in addition to the New York Times, this judge's decision is based on unnamed, unidentified press stories from the media, the legacy media, obviously impartial, unbiased sources of information. By the way, this is all following what's called a bench trial. So a trial without a jury in front of these 3 district court judges. You think any of this was subject to cross-examination? No, of course not. They didn't bring in the New York Times news article, the contemporaneous press coverage, so what they claimed could be challenged for credibility and veracity in cross-examination. Contemporaneous press coverage indicated that partisan rather than racial motivations were behind the White House redistricting. The same New York Times article reported that the push from Washington had unnerved some Texas Republicans who worried that reworking the boundaries of Texas House, I don't have to read it. I just want to drive home this point. At an emergency meeting in the Capitol, shortly before the New York Times article, so it's not even the substance of the article now, it's the timing of the article that matters to this judge. And you'd think it would be really irrelevant because the meeting he's about to complain about happened before the article was published. So the article could not have triggered or influenced the meeting, but he wants to mention it. He's giving a communist fist pump. Comrade, New York Times, your name is in my mouth. At an emergency meeting in the Texas Capitol shortly before the New York Times article was published, congressional Republicans from Texas professed little interest in redrawing the districts. At the bench trial this court held in May and June 2025, when counsel, a lawyer, asked Senator Huffman whether the Texas legislature might be considering redrawing the congressional districts. As the New York Times had reported just one day earlier, the senator unequivocally responded, they are not. So one senator in the legislature hadn't gotten the memo. Of course, they did go on to redraw it. Then this judge decides that he's going to attack the Department of Justice letter from Harmeet Dillon. He's going to personally denigrate the executive branch's chosen lead counsel on this case, Harmeet Dillon. The judge writes, it's challenging to unpack the Department of Justice letter, understand it, is what he means, because it contains so many factual, legal, and typographical errors. Indeed, even attorneys employed by the Texas Attorney General, who professes to be a political ally of the Trump administration, describe the DOJ letter as legally unsound, baseless, erroneous, ham-fisted, and a mess. The gist of the letter, though, is that the Department of Justice is urging Texas to change the racial compositions of congressional districts 9, 18, 29, and 34. Remember, all of the jurisprudence on the Voting Rights Act of 1965, the purpose of it is to adjust the racial compositions of congressional districts. That's how it's used by the federal courts. The DOJ claimed there was racial gerrymandering. So according to the DOJ, the answer is to change the offending district's racial makeup so that they no longer qualify as these coalition districts, right? Where a bunch of minority groups are put together, whatever it takes to make sure that white people are not in the majority. And this decision continues along these lines for another 140 pages. 140 pages, which is why I had decided early on that I was not going to subject all of you to this. Whoops, I lost my, hold on a second. I lost my StreamYard. I lost my show. Oh, here it is. Moving too much stuff around. All right. So that's all I'm going to cover from the order itself, just to give you a flavor. By the way, we learn a lot more about it because of the critique in the dissent, and it's the dissent that I really want to share with all of you. Let's see, here it is. This judge, Jerry Smith, is on fire. Again, I'm not sure I've ever seen this is the kind of dissent that Supreme Court Justice Ketanji, I'm not a biologist, how would I know what a woman is, Jackson, she dreams of being able to write a dissent like this. Dreams of it. Will never be within her meager capabilities. So let's get right to it. And this is 104 pages. We're only going to read about the first 20 pages and then the last page, the summary page. Okay, let me take a sip to get ready. Gird your loins, folks. And let me get my red pen for this one. Jerry E. Smith, circuit judge. Whoops, that's not my red pen. Let's try that again. There we go. Jerry E. Smith, circuit judge, dissenting. His starting quote, fasten your seatbelts. It's going to be a bumpy night. He writes, he just starts off so hot already. I dissent from the entirety, every word, every punctuation mark, the margins are offensive. I dissent from the entirety of Judge Brown's opinion granting a preliminary injunction. Preliminary statement, which is not common in a dissent. He says, I append this preliminary statement to dispel any suspicion that I'm responsible for any delay in issuing the preliminary injunction or that I am or saw slow walking the ruling. I also need to highlight the pernicious, define pernicious, harmful in a gradual way. The pernicious judicial misbehavior of U.S. District Judge Jeffrey Vincent Brown, who wrote the majority opinion here. Footnote number 2. What's footnote number 2 say? That's here. When misbehavior or even irregular procedural behavior occurs, there's ample precedent for bringing it to the attention of the public. Continuing with Judge Smith here. In my 37 years on the federal bench, this is the most outrageous conduct by a judge that I have ever encountered in a case in which I have been involved. In summary, Judge Brown has issued a 160-page opinion without giving me, one of the judges on the 3-judge panel, any reasonable opportunity to respond. I will set forth the details and the readers can judge for themselves. The 3-judge district court, so him, Of course, Smith, Brown, and I don't know who the third judge was. Doesn't matter. The three-judge court held a 9-day evidentiary hearing, bench trial on the motion for preliminary injunction. The hearing was concluded on Friday, October 10th. The judges immediately retired to confer with each other. Judges Brown and Guadarrama, that's the third judge. That's number 2 in the 2-1 decision. Guadarrama. How many judges named Guadarrama does America really need? Guadarrama. Who appointed federal judge Guadarrama? I wonder. I wonder if it's a woman. No, Barack Obama. Barack Obama. You know, I wonder, where was federal judge born? In New Mexico. So at least it's an American-born judge. So that was Obama. Who appointed federal judge Brown? I should have checked this before. Sorry, folks. Oh, he was appointed by Donald Trump in his first term. And who appointed federal judge Jerry Smith, who's writing this dissent? Ronald Reagan. Yeah, Jerry Smith has been around for a hot second. He was raised to the federal bench in 1987. I wasn't even a lawyer yet. That was a long time ago. 1987. I was just graduating from college. Just about to. All right, back to this. Judges Brown and Guadarrama voted to grant the preliminary injunction. I voted to deny. It was understood that the majority judges would begin putting together an opinion. During the next 26 days, there was silence, nary a word from either judge. On Wednesday, November 5th, Judge Brown sent me a 13-page outline of the expected majority opinion so that you and your chambers might be able to begin preparing your dissent. Then I heard nothing else for a week. On Wednesday, November 12th, Judge Brown sent a message stating, "We currently anticipate issuing the injunction on Saturday, November 15th. We will endeavor to get you a draft before we issue it. Sadly, we do not believe we can wait for a dissenting opinion before we rule. The fuse is simply too short in light of Purcell." So Purcell, this is nonsense, but Purcell is a court decision that basically says the federal courts are not supposed to make changes to voting procedures shortly before an election because it's too disruptive. So if a court orders a change in districting and voting procedure just before an election, that can be thrown out by a higher court. So he says the fuse is simply too short in light of Purcell. In other words, until the time for the election arises. Of course, this is for November 2026 election. I don't think Texas has even held the primaries yet. I don't believe that happens until early next year. So Purcell, this notion that we're getting too close to the election, that we have to rush this, doesn't really seem a compelling argument. But anyway, Judge Brown said the fuse is simply too short in light of Purcell. We can't wait for your dissent. However, we will note on the opinion that you are dissenting. We're not trying to cut you out. We just don't have the time. Ideally, of course, we'd like to have seen your dissent before we issue our opinion, but that will also be impossible. Yes, Judge Jerry Smith in the dissent writes, you heard it right. To summarize, in case the reader doesn't get the point, Judge Brown was announcing that he would issue an opinion 3 days later, an opinion that I hadn't even seen and might not be furnished before its issuance. That is unthinkable, but it occurred and not accidentally. A day later, at 10:31 p.m., when I'm normally asleep, Thursday, November 13th, Judge Brown sent the message saying, I've attached a complete draft of our memorandum opinion and order granting the preliminary injunction against the new Texas map. We still have revisions to make, but we wanted to get this to you to assist in the preparation of your dissent. The draft was 168 pages, 655 footnotes, and departed noticeably from the outline I had previously received. Again, this was the very first actual opinion draft that I had been allowed to see. 5 calendar days before the actual opinion was sprung. I was out of town on Thursday and Friday, November 13th and 14th, to attend the funeral of another district judge. In my absence, my staff continued working. I drove back home on Friday, arriving after midnight, so that my staff and I could spend all day Saturday and Sunday working on the dissent. Early Sunday morning, November 16th, Judge Brown sent a message stating, "I've attached a newly revised draft of our majority opinion. We're still making revisions, but this is pretty close to the final version. We're now hoping to issue it on Tuesday, November 18th, which of course they did yesterday. That second draft was 161 pages and contained some substantive revisions from the draft just 3 days earlier. I replied that I'd been out of town, was writing the dissent all weekend, would be on the road all the next day, Monday, to attend graveside services for the deceased federal judge. I said Judge Brown had no business issuing an opinion as soon as Tuesday. At 11:27, Tuesday, November 18th, Judge Brown wrote the following: "I've attached a final version. We still intend to issue it today. I'm sorry we can't wait for your dissent. Purcell compels us to get the ruling out as soon as we possibly can. It turns out that's today." That third version, 160 pages, was issued a few minutes later with a small number of additional changes and was so ordered and signed on Galveston Island this 18th day of November 2025. This outrage speaks for itself. Any pretense of judicial restraint, good faith, or trust by these two judges is gone. If these judges were so sure of their result, they would not have been so unfairly eager to issue the opinion without my dissent. Or they could have waited for the dissent in order to join issue with it. What, indeed, are these judicial cowards afraid of? I added judicial cowards there. Judges on multi-judge courts understand how important is the deliberative process to fair and accurate judicial decision-making. As I say later in this dissent, judges get paid to disagree as well as to find common ground. Judges in the majority don't get to tell a dissenting judge or judges that you can't participate. If the two judges on this panel get away with what they have done, it sets a horrendous precedent that might makes right and the end justifies the means, which of course is exactly what progressive fascists believe. The two-judge majority might even say, "We don't need to wait for your dissent," and wouldn't read it if we did. Here, that sort of happened. The entry on the district court docket brings up only Judge Brown's opinion. The reader has no access to this dissent without opening a separate, non-consecutive docket entry. So this majority has won in terms of diminishing the impact of the dissent and the public's access to it. In the interest of justice, one can only hope it is a Pyrrhic victory. When I was newer on the bench, a friend asked me, "Now that you've been a judge for a few years, do you have any particular advice?" I replied, "Always sit with your back to the wall." Bam! That was just the preliminary comment. Now we get to the dissent. And this, again, is fire. Look at these first two sentences. The main winners from Judge Brown's opinion are George Soros and Gavin Newsom. The obvious losers are the people of Texas and the rule of law. I, Judge Smith writes, I dissent. In the interest of time, because he wanted to follow it as close on the heels of the majority opinion as possible, this dissent is admittedly a bit disjointed. Usually, in dissenting from an opinion of this length, remember, the majority opinion is 160 pages. Normally, I would spend more days refining and reorganizing the dissent for purposes of impact and readability. But that approach is not reasonably possible here because these two feckless judges in the majority have not allowed it. The resulting dissent is far from a literary masterpiece. If, however, there were a Nobel Prize for fiction, Judge Brown's majority opinion would be a prime candidate. Judge Brown could have saved himself and the readers a lot of time and effort by simply stating the following. I just don't like what the Texas legislature did here. It was unnecessary. It seems unfair to disadvantaged voters. I need to step in to make sure wiser heads prevail over the nakedly partisan and racially questionable actions of these zealous Texas lawmakers, just as I did to the lawmakers in Galveston County in Petaway. Another decision by the same judge who wrote the majority here that got overturned. I'm using my considerable clout as a federal district judge to put a stop to what I think are bad policy judgments. After all, I get paid to do what I think is right. Back to Judge Jerry Smith here in the dissent. He writes, in 37 years as a federal judge, I've served on hundreds of 3-year panels. This is the most blatant exercise of judicial activism that I have ever witnessed. There's an old joke. What's the difference between God and a federal district judge? Answer: God doesn't think he's a federal judge. Or a different version of that joke. An angel rushed to the head of the heavenly host and says, we have a problem. God has delusions of grandeur. The head angel calmly replies, what makes you say that? And the first angel whispers, he's wearing his black robe and he keeps imagining he's a federal judge. Only this time, the jokes aren't funny. Again, I dissent. Judge Brown, who wrote the majority, is no stranger to a spirited attack on a legislative body's exercise of its duly elected power to redistrict, before being roundly reversed by the Fifth Circuit sitting en banc. Judge Brown, imagining himself to be a legislature, imagining himself to be a legislature, wrote the following. This is, again, a case in which he got reversed. The 2021 redistricting process occurred within a climate of ongoing discrimination affecting Black and Latino voting participation. Black and Latino residents of Galveston County bear the effects of discrimination. Anglo commissioners are evidently not actively engaged in specific outreach to Galveston County's minority residents. Black residents in Galveston County are more likely to be arrested, and Black and Latino residents comprise a disproportionate percentage of jail and prison inmates. You know, more than 50% of the violent crime in America is committed by the 5% of the population that is young Black males. Might that explain a disproportionate arrest and incarceration rate? That has nothing, by the way, to do with voting. Continuing with Judge Brown, the plaintiffs here do not need, this is in that earlier case where he got reversed, the plaintiffs do not need to initially show that partisan affiliation does not cause divergent voting patterns. Practices exist in Galveston County, including voter purges and racially disparate access to polling places. It's stunning how completely the county extinguished the Black and Latino community's voice on its commissioner's court. during redistricting in 2021. This is not a typical redistricting case. What happened here was stark and jarring. The commissioner's court transformed Precinct 3 from the precinct with the highest percentage of Black and Latino residents to that with the lowest percentage, and the judge doesn't like it. The circumstances and effect of the enacted plan were mean-spirited and egregious, given that there was absolutely no reason to make changes to Precinct 3. That was the case of Petaway, reversed. Again, same judge who wrote the majority here, Judge Brown. Petaway reversed by the Fifth Circuit en banc. Judge Brown concluding that the en banc fifth panel concluding that the district court, Judge Brown, was wrong. The en banc court remanded for the district court to consider the intentional discrimination and racial gerrymandering claims. Today, as a legislator/activist jurist, Judge Brown finds a likelihood of success on the current racial gerrymandering claims. In regard to the Galveston County matter, stay tuned for what Judge Brown will rule on remand. In regard to the preliminary injunction in the case at hand, read on. The ultimate question is whether unrestrained ideological judicial zeal should prevail over legislative choice. This, writes Judge Jerry Smith in the dissent, this is not my first rodeo. 14 years ago, dissenting from a flawed 3-judge redistricting order in this very court, I wrote the following. Reapportionment is primarily a matter for legislative consideration and determination. Accordingly, district courts are bound to follow the policies and preferences of the state legislature. In the reapportionment plans proposed by the state legislature, whenever adherence to state policy does not retract from the requirements of the federal Constitution. The aim of giving such due regard to plans proposed by the state is so the court will not preempt the legislative task nor intrude upon state policy any more than necessary. Justice Samuel Alito, in a recent debate discussing activist judges, explained that judges are not theorists or social reformers. Because the conscientious and well-intentioned majority has ventured far, he means the majority on that 3-judge panel, has ventured far beyond its proper role, I respectfully dissent, in the hope that on appeal, the Supreme Court will provide appropriate and immediate guidance. 2 weeks later, the Supreme Court noted probable jurisdiction and set a special oral argument. Less than 2 weeks after the argument, the Supreme Court unanimously vacated the order from which I had dissented. In other words, the Supreme Court said, I, Judge Jerry Smith, was right. Unfortunately, here we go again. And he writes for the 3rd time, I dissent. Speaking of fortune, Judge Jerry Brown writes in his dissent, just a few weeks ago, not Jerry Brown, Jerry Smith. Just a few weeks ago, the Fifth Circuit answered the main question at hand, holding that the most obvious reason for mid-cycle redistricting is, of course, partisan gain. The question for this 3-judge district panel is whether the Texas legislature did its mid-decade congressional redistricting to gain political advantage, which is permissible, or instead because the main goal of the Texas Republican legislatures is to slash the voting rights of persons of color, which would not be permissible. Once again, here we go again. Criticizing the behavior of Department of Justice lawyers in the last decade's redistricting battle, I noted the following. It was obvious from the start that the DOJ attorneys viewed state officials and the legislative majority and their staffs as a bunch of backwoods hayseed bigots who bemoan the abolition of the poll tax and pine for the days of literacy tests and lynchings. And the Department of Justice lawyers saw themselves, this would have been the Biden lawyers, And the Department of Justice lawyers saw themselves as an expeditionary landing party arriving here just in time to rescue the state of Texas from oppression. The Biden Department of Justice, moreover, views Texas redistricting litigation as the potential grand prize and lusts for the day when it can reimpose pre-clearance via Section 3 of the Voting Rights Act of 1965. Judge Jerry Smith continues in his dissent. Although the United States Department of Justice is no longer participating in this case, because of course now we have the Trump Department of Justice, the same attitudes about Texas Republican legislators have been reflected in the testimony of multiple experts and witnesses presented by these plaintiffs, occasionally, but not always, by their talented counsel and the statements of some parties. Because the obvious reason for the 25 redistricting is, of course, partisan gain, Judge Brown commits grave error in concluding that the Texas legislature is more bigoted than political. And for the fourth time, I dissent. It's all politics on both sides of the partisan aisle. George and Alex Soros have their hands all over this. One of the plaintiff's top experts is Matt Barreto. He is a paid Soros operative and does not attempt to hide it. His CV, his resume, confirms it. He expects to receive $2.5 million from George and Alexander Soros. Nor is this something new. Soros has been pumping money into Barreto's UCLA voting rights project for years, and this steady supply of money won't stop until 2026 at the earliest. Unsurprisingly, Barreto has been on quite a roadshow for years, parading across the country, opposing Republican redistricting. This is the tip of the iceberg. The lawyers are involved as well. To his credit, the lead counsel for plaintiffs does not try to hide it either. Chad Dunn acknowledged in open court he works with Barreto at the same voting rights project that receives Soros funding. Dunn is a respected attorney in Texas election cases, most recently serving as counsel in the Jackson case, in which the Fifth Circuit squarely declared the political nature of mid-decade redistricting. Mr. Dunn, along with his Voting Rights Project colleague Sonny Wachman, also represented the plaintiffs before Judge Brown in the overturned Pettaway case, which was overturned by the en banc Fifth Circuit. Mark Gaber also appeared in Pettaway and Jackson. He's the senior redistricting director at Campaign Legal Center, another Soros-funded group. It doesn't stop there. The Mark Elias Law Group draws from the Soros coffers too. Counsel for the Instant Gonzalez plaintiffs, David Fox, is a partner at Elias, which has collected more than $104 million from Democrat Party committees and donors, including Mr. Soros. Firm chair Mark Elias formed entities tucked inside large existing nonprofits that raise tens of millions of dollars from some of the richest donors on the left, including from foundations funded by Mr. Soros. On a silver platter, Judge Brown hands Soros a victory at the expense of the people of Texas and the rule of law. Judge Brown won't tell you that. I just did. What's this footnote 17? Footnote 17 reads, the point is that it's all about politics, and the federal courts are supposed to be the apolitical branch of government. You fight politics in the legislature and the governor's office. These plaintiffs and their counsel and their experts are welcome in this court to present their partisan views, as is the state of Texas. But if we are to tell it like it is, we must recognize that the well-funded machinery that I have just identified is all about that political crusade that these parties are free to pursue under the First Amendment. And the public is entitled to know who's really driving this bus. The most obvious reason for mid-cycle redistricting, of course, is partisan gain. That is the core of this case, and I will repeat it ad nauseum. Judge Brown won't tell you that. I just did. Relatedly, Gavin Newsom, governor of California, took a victory lap in Houston to celebrate the Democrat redistricting win with Proposition 50. Indeed, he did so on rival Governor Greg Abbott's home turf Saturday and called on other blue states to push back on GOP efforts to retain control of the House. And after the improperly premature issuance of Judge Brown's opinion, the Houston Chronicle pointed out that Gavin Newsom quickly tweeted, "Donald Trump and Greg Abbott played with fire, got burned, and democracy won. This ruling is a win for Texas and for every American who fights for free and fair elections." Judge Jerry Smith here writes, "That tells you all you need to know. This is about partisan politics, plain and simple. And for the fifth time now, I dissent." Regardless of one's political slant, Judge Jerry Smith writes in his dissent, it's obvious what Texas is trying to do in 2025. The Republicans' national margin in the House of Representatives is so slim that squeezing out a majority might even depend day to day on whether some seats are vacant because of deaths or resignations. In 2021, the Texas legislature, with both houses controlled by Republicans, devised a strategy of creating safe seats for both Republicans and Democrats, but with a decided majority of the state's delegation still Republican. Whether, as a matter of political clout, that was the wisest strategy is disputed, and indeed was fulsomely debated in 2021. Why are the Republicans giving the Democrats unnecessary congressional seats? Why are they being the nice guys? Do the Democrats ever return that favor? Of course not. In mid-2025, the strategy changed. The new plan was to make more seats winnable for Republicans by moving some Democrats incumbents from their districts and rendering other districts unwinnable by Democrats. That sacrificed the wider margins in some of the old districts. The trade-off is obvious. There is some speculation that this new strategy will backfire on Republicans in 2026 because if they do poorly in the midterms, the new Republican seats created in 2025 will be a Pyrrhic victory because they will lose elections in the closer districts. That is purely a matter of political strategy that federal judges have no business touching. The challenge faced by these plaintiffs and Judge Brown is to explain how it could be that the Republicans would sacrifice their stated goal of political gain for racial considerations. It makes no sense to advance the notion that the Republican legislature would draw districts for the purpose of disadvantaging racial and ethnic minorities if, by doing so, they lessen the number of new Republican seats they might gain. The plaintiff's theory is both perverse and bizarre. They actually contend that if the Republicans are sincere about gaining more seats, they could have drawn not 5, but 6, 7, or 8 additional seats, and that the reason they did not is that the real reason for the redistricting is racial animus. The absurdity of that notion speaks for itself. Yet it's all that the plaintiffs and Judge Brown have to offer to defeat the state's claim that the 2025 lines were drawn for the sake of politics and not race. That's the central dispute in this case, but the most obvious reason for mid-cycle redistricting, of course, is partisan gain. And now the 6th time. I dissent. Judge Brown rushes to issue this injunction before the tension between Section 2 of the Voting Rights Act and the racial gerrymandering jurisprudence is resolved by the Supreme Court in its currently pending Calais case out of New Orleans, which I've covered with all of you at length. Given Judge Brown's creative read of the facts and novel approach to the law, he should have considered denying this injunction for that reason alone, that the Supreme Court might shortly be changing all the rules, recognizing that a fundamental shift in voting rights jurisprudence is not unlikely. Because the power to stay proceedings is incidental to the power inherent in every court to control the disposition of the causes on its docket with economy of time and effort for itself, for counsel, and for litigants, it would have been well within the authority of this three-judge court to put things off, to stay the proceedings until we heard from the Supreme Court on whether and how it was going to rewrite the redistricting laws. The fact that Calais, the Louisiana case, may fundamentally change the nature of this case also weighs in favor of pausing the proceedings. It is reckless for this court to proceed with opining on the merits, which amounts to nothing more than a general guess as to whether existing voting jurisprudence will survive whatever the Supreme Court does in Calais. Now it gets personal. Judge Brown, who wrote the 160-page majority opinion from which Judge Jerry Smith is dissenting here, Judge Brown has a lingering habit. He correctly recites part of a legal principle, then veers off track along a spectrum, intentionally misleading at best to false at worst. His opinion is replete with selectively copying and pasting parts of legal rules or standards. Beyond that, things get dicey. This holds especially for Judge Brown's discussion of the standard for a preliminary injunction, which we've covered many times, right? The four standards are likely to win on the merits, irreparable harm, weighing the factors of equity, fairness, and the public interest. Really, the first two are the most important. Likelihood to win and risk of irreparable harm if an injunction is not granted. Judge Brown, Judge Jerry Smith continues, Judge Brown admits that the first factor, likelihood of success on the merits, is the most important, and that granting a preliminary injunction is an extraordinary and drastic remedy. You wouldn't know it by the many dozens, scores of injunctions issued against our democratically elected Article 2 executive branch president, would you? A preliminary injunction is supposed to be an extraordinary and drastic remedy which should not be granted unless the person asking for the injunction clearly carries the burden of persuasion. That's all standard law for an injunction. But then Judge Brown's opinion goes entirely off the rails. Judge Brown quibbles with the omission of the word substantial next to the phrase likelihood of success in the merits, because that's the element, right? Substantial likelihood of success. In the Fifth Circuit mid-decade redistricting opinion from just a few weeks ago, claiming that the omission suggests that the plaintiff need only show some likelihood of success on the merits. This is intentionally misleading at best and disingenuously false at worst. Liar, liar, liar. You don't often see one federal judge call another a liar. How does Judge Brown get there? Judge Brown justifies his wish list formulation of the first factor, substantial likelihood of winning on the merits, by noting the factual dissimilarities between Jackson, a previous redistricting case, and this case. Both involve Texas mid-decade redistricting at the preliminary injunction stage, but surely he knows that the phrase extraordinary and drastic remedy never appears in Jackson. Judge Brown, relying on the factual and procedural analogies between the two cases, would lead the reader to think that gives him carte blanche authority to excise the extraordinary and drastic remedy from his opinion as well. Nonetheless, he keeps the phrase extraordinary and drastic remedy in the standard because he knows he cannot remove the phrase at will. It's part of the standard for a preliminary injunction. A preliminary injunction is supposed to be an extraordinary and drastic remedy. Judge Brown, no stranger to inconsistency, is wrong. He should give less consideration to the omission and more consideration to the actual words on the page. Judge Brown accurately cuts and pastes the following. A preliminary injunction is an extraordinary and drastic remedy which should not be granted unless the movement clearly carries the burden of persuasion and the likelihood of success in the merits is the most important factor of the framework. But the cut and paste job is selective. Judge Brown left out the fact that given attention to the relevant cases cited in Jackson, the most important factor language in Jackson is a direct quote from Mock v. Garland. And any cursory reading of Mock easily reveals that the word substantial, the word Judge Brown tries to avoid, is part of the first factor in no uncertain terms. A substantial likelihood of success is what's required for that first element of a preliminary injunction. But Judge Brown leaves out the word substantial. Judge Brown doesn't tell you that. I just did. This opinion of Judge Brown is caught in an illogical straitjacket from which it cannot escape. Knowing that his argument is weak, Judge Brown declares that the omission of the word substantial doesn't matter anyway, because the Fifth Circuit has a sliding scale approach to likelihood of winning on the merits, which is instead called likelihood of success. With a magic wand, the quibble with the omission of the word substantial is no longer consequential and vanishes into the ether. This is part of the activist, results-oriented bag of tricks that tinkers with the allegedly most important first factor, substantial likelihood of success on the merits, such that the quibbles that he proclaimed mattered no longer do. Judge Brown says that where the other factors are strong, the party seeking the injunction need only show some likelihood of success on the merits to obtain a preliminary injunction. Again, this is intentionally misleading at best, or he is an effing liar at worst. There he goes again. Judge Brown overlooks what immediately follows the passage on which he relies. He ignores this part. Where the other factors are strong, a showing of some likelihood of success in the merits will justify temporary injunctive relief. But when a plaintiff applies for a mandatory preliminary injunction, such relief should not be granted, except in rare instances in which the facts and law are clearly in favor of the party seeking the injunction. All this conditional language, Judge Brown leaves out. Judge Jerry Smith writes, Judge Brown, the majority author, is wrong on multiple levels. First, he claimed that the first factor alone suffices, indicating that the other factors don't matter. Second, the other factors are extraordinarily weak in this case. Third, that Title Max case differentiates between a temporary injunctive relief like a TRO, which only lasts for 2 weeks, and the narrower category of a mandatory preliminary injunction, which is durable for the duration of the litigation. And remember, this litigation's been going on for 4 years already. Judge Brown must surely know that, Judge Brown must surely know that, which is likely why he cherry-picked the language he liked, some likelihood of success on the merits, omitted the language he didn't like, temporary injunctive relief and inserted what he wanted, a preliminary injunction. If this is not I'm so excited. If this is not judicial activism, I'm not sure what would be. Fourth, Judge Brown is issuing a mandatory preliminary injunction because he is enjoining the implementation of the 2025 Texas Congressional map and requiring Texas to use the 2021 map. Fifth, the facts and law are not clearly in favor of the party seeking the injunction. If this were a law school exam, the opinion of Judge Jeffrey Brown would deserve an F. An F. I see we got a couple super chats, so let me hit those before they get too old. A new member, Ooga Boogaloo. Welcome aboard, man. Welcome to the family. And Will Crump, $5, says, hopefully this sharply worded dissent will carry the weight when this travesty is appealed. I hope it is appealed on an expedited schedule. Texas filed an appeal with the Supreme Court yesterday, immediately after getting hit with the preliminary injunction. They filed their appeal with SCOTUS that afternoon. So it's on the desk of the Supreme Court now. It wouldn't surprise me if they issued an immediate stay of this preliminary injunction, considering in just a couple weeks they're going to address the whole redistricting case of Louisiana versus Calais. Well, look at this. Thank you, man. Mike, very generous. No question or comment. Just $20 cash money. So Emily will get some nice flowers this weekend. Thanks, Mike. Very generous. Continuing now with the dissent of Judge Jerry Smith. Metaphorically murdering judicial colleague, federal judge Jeffrey Brown. Remember that recent Fifth Circuit redistricting case? The one that Judge Brown said was procedurally and factually analogous to this case? Judge Brown conveniently omits, meaning of course dishonestly, the key sentence in that mid-decade redistricting case. The most obvious reason for mid-cycle redistricting, of course, is partisan gain. Judge Brown doesn't even pretend. Whoop, I forgot to pull it back up. Here we go. Sorry. Judge Brown doesn't even pretend to grapple with Justice Stevens' relevant quote. It is far from a mere coincidence that the opinion goes to the mats over the omission of one word, substantial, when it suits the results-driven outcome, but overlooks the most significant sentence about the most obvious reason for mid-decade redistricting, which is partisan gain, which is completely permissible. The combined weight of the procedural and substantive law is against what these plaintiffs and Judge Brown are trying to do. Not only do the plaintiffs who want the injunction want the new 2025 map that gives Texas Republicans 5 more seats, not only do the plaintiffs have to show clearly that they are entitled to the drastic and extraordinary remedy of a permanent preliminary injunction, but they must also do so when the Supreme Court and the Fifth Circuit precedent is stacked against them. Nothing in any bag of results-oriented tricks can save that wished-for result, and Judge Brown, who wrote the majority opinion, is an unskilled magician. The audience knows what's coming next. Moving past the recitation of the preliminary injunction factors, Judge Brown does not hesitate to make excuses for the plaintiffs and their quote-unquote experts for failing to produce an Alexander map. He has no other choice on the merits. He claims the plaintiffs didn't have time and that it would be too much to ask plaintiffs to produce an Alexander map at this late stage of the litigation. That is not how the law works. for a preliminary injunction. I actually don't know what an Alexander map is. What is a Fifth Circuit Alexander map? The term Alexander map likely refers to a redistricting map involved in a specific voting rights lawsuit within the jurisdiction of the Fifth Circuit. Thomas v. Bryant. Let's see. Oh, I think what they mean here by Alexander map is that the plaintiffs here did not present their own new map, their proposed redistricting map that would address their concerns. They're simply demanding that the map be reverted back to 2021, the existing map of 2021. So that makes sense. So they said the experts wouldn't have time to draw their own map. It would be too much to ask them to do that. But that is not how the law works for a preliminary injunction. Judge Brown overlooks that the plaintiffs seeking a preliminary injunction bear the burden of proving they are entitled to it with nothing more than meager direct evidence. In this case, plaintiffs must produce their own proposed map, plain and simple. They either can't or don't want to because it's really all about politics. In any event, this court has no business coming to the rescue by giving students who didn't do their homework a homework pass, nor should Judge Brown make excuses for them failing to show their work. The last time I checked, a preliminary injunction is an extraordinary and drastic remedy. This is serious business we are about. Judge Brown boasts that plaintiff groups have successfully shown a likelihood of success, but not a substantial likelihood, on their racial gerrymandering claims, and that alone suffices for the preliminary injunction. Yes, you read that right. Judge Brown is so determined to issue an injunction that he does not need any help from the other factors. How could that be? Because Judge Brown said so. So there's only one factor for a preliminary injunction, according to Judge Brown. With his creative formulation of the preliminary injunction standard, Judge Brown is intentionally misleading at best or an effing liar at worst. He engages in several layers of sophistry, word games, to water down the potency of the most important first factor and to grease the skids for the injunction he wants to issue. He doesn't even make it clear which articulation, which flavor of the first factor he uses. Consider this bizarre multiple choice question from hell. Which formulation of the first preliminary injunction factor is he using? Is it the likelihood of success factor, that is 1, the watered down formulation because of the missing word substantial, likelihood of success, or 2, the watered down formulation because of the supposed sliding scale, or 3, the watered down formulation because of both the sliding scale and the omission of substantial, or 4, the substantial formulation but with the sliding scale, or the substantial formulation without the sliding scale, or whatever Judge Brown thinks the law should be, or 7, something else? Confused yet? You can thank Judge Brown for that. If we were to take Judge Brown at his word, look at the italic. If we were to take him at his word, that the first factor is dispositive, and it is not under the law to grant a preliminary injunction, it's not apparent why Judge Brown feels the need to even talk about the other factors. His mind is made up on the first factor alone. But I will move on from that to discuss them anyway. Judge Brown claims that the plaintiff groups who want the 2025 map, good for the Republicans, thrown out, have made a very strong showing on the irreparable injury factor. That's the second factor of the four for a preliminary injunction. Not so fast! Not so fast, says Judge Jerry Smith, writing this dissent. First, the plaintiffs are unlikely to succeed on the merits of their racial gerrymandering claim. They're not likely to win. So they're not likely to suffer harm. It's only harm if you don't own it. If it's not what's legally called for. Second, the plaintiffs, bearing the burden of clearly showing they are entitled to an extraordinary and drastic remedy, cannot use circular reasoning to bootstrap their alleged likelihood of success from factor one into showing irreparable harm from factor two. Then they're just the same factor. In fact, the harm goes the other way. When a statute is enjoined, the state necessarily suffers the irreparable harm of denying the public interest in the enforcement of its laws. Judge Brown caps off the section by returning to the sliding scale again, the same one he claimed was not necessary, to reiterate his preferred standard that plaintiffs need to show more than just some likelihood of success on the merits to obtain a preliminary injunction, but not much more. This is wrong. The standard is substantial likelihood of success on the merits to get a preliminary injunction. Judge Brown gets creative with the final two factors of a preliminary injunction, balance of the equities and public interest, and stands the Purcell framework on its head. Remember, Purcell is the case that says you shouldn't make changes just before an election, that federal courts shouldn't make changes to election procedure or districts right before an election. Judge Brown wants a federal court to swoop in and redo a state's election laws in the period close to an election and issue a late-breaking injunction with disastrous, unintended consequences for candidates, political parties, voters, the state, counties, and local officials. This injunction will affect down-ballot races because those interested in running for Congress must make plans not to run for state house and senate seats, and others are sure to run for the newly vacant state seats. This trickle-down effect is only the tip of the iceberg. Judge Brown's injunction is the epitome of judicial tinkering. The 2025 map is currently the status quo. By the way, temporary restraining orders and preliminary injunctions are supposed to maintain the status quo. Counties have begun preparations with the 2025 map, educating local officials about the current law. Although Judge Brown acknowledges that the state of Texas has the prerogative to toy with its election laws, he quickly contradicts himself that the state invited this issue by enacting a new map too close to the election, within Purcell's range. Contrary to what Judge Brown wants to hear, the state, which has the prerogative to redistrict mid-decade, is in a fundamentally different position from that of a federal court. Purcell, that limitation on Purcell that you don't change things close to an election, that's a limitation on federal courts changing the rules. It's not a limitation on the state legislature changing the rules. So the legislature is in a fundamentally different position than that of a federal court, which must exercise extraordinary caution before intermeddling with an intimately vital local prerogative such as redistricting. Judge Brown parrots the plaintiff's argument that the state of Texas is using the 2021 map in some limited circumstances, but Judge Brown doesn't attempt to grapple with what the Fifth Circuit has made clear. A duly enacted Texas congressional districting map is the status quo. There, the Fifth Circuit said in no uncertain terms that the Texas legislature's duly enacted law creating a new congressional districting map became the new status quo under Texas law. Instead, Judge Brown dishonestly cherry picks the status quo language out of another Fifth Circuit case where the court made it clear that the Supreme Court has instructed that we should carefully guard against judicially altering the status quo on the eve of an election. Whether Judge Brown likes it, he needs to acknowledge two realities. First, the duly enacted 2025 Texas congressional map is the status quo. But true to form, Judge Brown prefers living in Fantasyland. Second, Judge Brown's late-breaking 11th hour injunction is the precisely kind of judicial tinkering and judicial altering that the Supreme Court has repeatedly warned us about. I guess Judge Brown needs another reminder. Whether Judge Brown likes it, gravity exists. So does the weight of Purcell against his late-breaking 11th hour injunction. And there's more. Judge Brown idiotically fails to recognize that some of these plaintiffs are seeking an equitable remedy, namely a preliminary injunction, with unclean hands. Contrary to Judge Brown's inventive contention that the state of Texas is to blame for the delay in dealing with these legal issues, some of the plaintiffs broke quorum. Remember when the Democrats fled from the Texas legislature? And they're now plaintiffs in this case trying to get this preliminary injunction. And they're the Democrats trying to get the improved 2025 map for Republicans thrown out. Some of the Democrat plaintiffs broke quorum and delayed the passage of the 2025 map for weeks. Judge Brown contradicts himself again, claiming that Purcell does not bar him from issuing an injunction and then turns around to wag his finger at the state for the cause of the delay. He is mistaken. The Democrat plaintiffs should not get the benefit of the delay they caused by breaking quorum. But Judge Brown has no problem giving plaintiffs an equitable remedy even though they have unclean hands. The so-called Purcell exception, which Judge Brown is eager to invoke, does not apply. Plaintiffs, the Democrats, caused undue delay. The merits are not remotely in their favor, and plaintiffs have not suffered an irreparable injury. For the seventh time now, Judge Jerry Smith writes, "I dissent." And then he starts getting into a lot of nitty-gritty detail. About another 80 pages. And I'm not going to read all that. But what I will do is go to the very end where he kind of summarizes things in his bulleted list. And he's still saying, again and again and again and again and again, I dissent. In fact, I wonder, I'll do a word search. Let's see. 15 times in his 104-page document, so more than once every 10 pages, he writes, I dissent. I've never seen that done before. Never. Usually they say at the beginning, I'm writing this opinion because I dissent with the majority, and then at the end they'll say again, I dissent. Powerful stuff. All right, wrapping up now. Federal Judge Jerry Smith in dissent against Federal Judge Jeffrey Brown's feckless order granting a preliminary injunction by the George Soros, Alex Soros, Mark Ilias Democrats against the Texas legislature's new 2025 congressional redistricting map that gave the Republicans 5 more congressional seats in Texas. Judge Smith writes, Judge Brown's analysis exposes either a naivete that is unbefitting of the judiciary, he's incompetent, or a willful blindness unbecoming of the judiciary. Collected below is a non-exhaustive list of the misleading, deceptive, or false statements Judge Brown put forward. The list would be considerably longer, but for the press of time. There's no lack of fodder here. And then we have the bulleted list of Judge Brown's many lies. Judge Brown says when the Trump administration reframed its request as a demand to redistrict on exclusively racial grounds, Texas lawmakers immediately jumped on board. Misleading at best. Judge Brown says, by all appearances, Republican lawmakers didn't have much appetite to redistrict on purely partisan grounds. Misleading at best. This is Judge Brown quoting from things like the New York Times article. Judge Brown says, and as far as some influential members of the legislature were aware, doesn't name them, the prospect of redistricting in 2025 was just a rumor. Misleading at best. Judge Brown says whether the other factors are strong, the party seeking the injunction has to only show some likelihood of success to get a preliminary injunction. Misleading at best. Judge Brown says Supreme Court precedent establishes that when a relevant political actor purposely establishes a racial target, that voters of a single race should make up no less than a majority, and the legislature follows those directions to the letter, such that the 50% plus racial target has a direct and significant impact on the district's configuration, a fact finder may permissibly conclude that race predominated in drawing those districts. Deeply misleading quote mining at best, intentionally deceptive at worst. He is an effing liar. Judge Brown says, why not just base the 2025 redistricting exclusively on another case? The answer must be that race were essential ingredients of the map, without which the 2025 redistricting wouldn't have occurred. This is just a lie. Judge Brown says the mapmaker has achieved an on-the-nose attainment of 50% minority status, I guess, in the challenged district, a feat that in this court's view, the map drawer would have been unlikely to achieve by blind adherence to partisan data at all, so it must have been racist. The district court deemed it far more likely the map drawer used a 50% racial target to deliberately redraw the challenged district as a majority-minority district. Deeply misleading, quote mining at best, intentionally deceptive at worst. Judge Brown says, even more notably, Dr. Duchenne's testimony, this is expert testimony by the George Soros expert, was effectively unchallenged. No defense expert submitted a report rebutting the Soros expert's findings. Misleading. Judge Brown says, in any event, if raising the floor to a value closer to 60% would have undermined that expert's conclusions, the state defendants could have introduced expert rebuttal testimony. Again, the state defendants let that Soros expert's testimony go unrebutted. That is a lie. Judge Brown says, in this case, late judicial tinkering with Texas's congressional map is not what could lead to disruption and to unanticipated unfair consequences for candidates, political parties, and voters. That is a lie. Judge Brown says the court adds that even Ms. Atkins testified that the Texas election officials and systems are more than capable of proceeding with the 2026 congressional election under any map. That is the law. That is a lie. Jerry Smith sums up. Judge Jerry Smith, in dissent, sums up the order for the preliminary injunction issued by his judicial colleague, federal judge Jeffrey Brown, by writing this. This order, this preliminary injunction order, replete with legal and factual error and accompanied by naked procedural abuse, demands reversal. Darkness descends on the rule of law. A bumpy night indeed. And that, of course, refers to the quote he started with. Fasten your seatbelts. It's going to be a bumpy night. Fire. Fire. Absolutely great stuff. All right, folks. So this has been appealed to the Supreme Court by Texas. The Supreme Court I would expect would issue a stay. There's good reason to issue a stay without even having to address the merits of all this, because they have the redistricting case of Calais, Louisiana v. Calais, that they're dealing with, which could resolve all of this. The Supreme Court could be radically redefining the rules for redistricting, in which case there's no need to decide this on the merits. Just stay the injunction, leave the 2025 map in place, and then we'll see how things fall out. Super chat. So if you're going to put a super chat in, now's the time, because I'm about to wrap up the show. Let's see. Grimwolf, $20, says, for some reason, I'm blocked from following you on X. I haven't even been able to interact with your posts to do anything that would warrant a block. Vet Wolf Pack. Huh. I mean, listen, I block a lot of people on X, so maybe I did something. Usually I need a reason. Let me take a look. Did you do something bad? Did you do something bad? Yeah, you are marked as blocked. Let's see. '81 followers. Well, do you do anything on X? Let's see. All right, man. I'll go ahead and unblock you. So we should be good to go. Vet Wolf Pack at Grim Saga. You should be good to go, my friend. And we'll see what happens. I do have a pretty short trigger on blocking on X. It's just a time management thing. There's a lot of accounts on X that are really denial of service accounts. They just want to waste your time. But I'm always amenable to unblocking if someone makes a request. A bot would not request to be unblocked, obviously. So that's all taken care of. All right, man. Was there anything else, folks? Anything else before I wrap up a show that I thought was going to be under an hour, but it turned into an hour and a half. All right, man. All right, folks. I'm going to go ahead and wrap up the show. You should expect to see me back again 11 a.m. Eastern time tomorrow morning with a tomorrow morning show. And until we meet up again. Oh, by the way, before I sign off, thank you, all of you, for being members. This was a members-only show, so it's just you here. We try to keep membership dirt cheap, 16 cents a day, $5 a month. But in the aggregate, your support makes all the difference for us. I'm only able to do all of this because you make it possible. So thank you. Thank you for allowing me. This is a lot of fun for me. For allowing me to do this. It's an amazing opportunity. And someone says Robert Gavea is still live. I didn't mean to step on his show. I hope I didn't. But in any case, Robert does good work. So as we sign out here, maybe you'll want to check Robert out. For us, until tomorrow morning, I remain attorney Andrew Branca for the Andrew Branca Show. Stay safe.